and welcome to Health and Information. This is February 2013. I'm Dr. James Bissland with Bissland Chiropractic. Before we start this month's program, I'd like to thank Dr. Lana Pinnell for joining us last month. And I hope that the information that she gave you and that we provided on the neuromuscular reeducation and spinal rehab gave you some good insight as to why we do what we do. This month's program, we're going to take a little bit of a turn away from treatment and protocols, and we're going to be talking about legal aspects of healthcare, some changes that are come along, as well as how to handle it if you're involved in an auto accident. And we have our guest today with us from the Benedict Law Office here in Tulsa, Lloyd Benedict, who is a personal injury attorney here in Tulsa. In fact, Lloyd was our first guest we had back in July of 2011 on our program. So Lloyd, welcome back to the program.
Thank you, Doc. Appreciate it. It's an honor to be here.
Lloyd and I have worked together for many years. Before he was an attorney, he was a paralegal. And so before we get on to the first topic, let's tell a little bit about your background so that people who either don't remember the program or didn't see the program then know who we're talking about.
Sure, absolutely. As Doc mentioned, I was a paralegal for about 14 years before I started attending law school. It was just another challenge that made sense just to continue my furtherance in the legal career. I had received my undergraduate from Oklahoma City University in business administration and more specifically in legal administration, and that was a good background to have to go to the University of Tulsa College of Law. Was there 4 years, worked full-time, struggling through with a family and 2 small kids and balancing the workload of what law school carries. But the legal background I had throughout the whole time had been always in personal injury, and with personal injury you get a little bit of everything. So going to law school, I had a lot of good background to be able to handle contracts or family law or probate or real estate law. Just a little bit of everything comes involved when you're dealing with personal injury. So it was a good background to have, and I kind of sailed, I don't want to say I sailed through law school, but it was not as hard as a task as I originally thought it would be. Got through there and again stayed primarily focused in personal injury, and I've been there since. All in all, I've been in personal injury since 1988, so it's almost 25 years. So
quite a while.
Yeah.
Now, when people are involved in an auto accident, first of all, they're injured. There's a lot of anxiety involved because the car's been damaged, they've been damaged. Now they got police coming around and ambulances and dealing with the legal aspects of it. So they make mistakes. What are the common mistakes that people make, and what should they not do following an accident?
I wouldn't even say it's mistakes, it's just oversight, because as you mentioned, there's a lot of distractions going on. Their injuries may be debilitating where they're just not able to do anything, and so they're just kind of left with whatever rescue services are being provided to them. But about 85% of the time, accidents, people are injured in accidents, and they don't have the broken bones or they don't have cuts or abrasions, but they're hurt. They're hurt with musculoskeletal type injuries. And with that, those folks there may not be readily feeling the symptomology of those injuries at the scene. In fact, it may take a few days or a few weeks later before those symptoms manifest themselves to the point where they feel like they need to get care. But the main thing is obviously to make sure that everybody's okay, including yourself. That's the primary concern. Even myself, who's been in an accident and had a lot of back experience, all that experience just goes out the window. It's a very overwhelming situation to be involved in an accident, and you would think that I would know what to do, but even my autopilot instincts wasn't allowing me to pick up on other things. But if you can go through and start getting some information at the scene, the police are going to get a lot of it. I always recommend having a police come to the scene of the accident regardless, unless it's Operation Slick Street. But they're going to do a lot of things that you're not going to think about like document the impact, skid marks, locations, measurements, things that you'll never be thinking about that, and that's why a police report's real important to have. Plus, they're going to have a finding of fault, and that's going to be important later on when you're dealing with the insurance companies, especially if the insurance companies try to turn this around and say that maybe you were at fault, a percentage or at whole. So that's another thing, is to contact the police and see if you can get them out there. It might be a small wait for you, but this is something that is in your best interest to be able to have the police be able to do. Some people feel that maybe it's not big enough to call the police. In that situation, you just have to use your own judgment on that. But if that's going to happen, you might want to start taking photographs with your cell phone. Photographs of the damage to your vehicle and to the other vehicle, the placement of the vehicles. If there's some witnesses around there, you might want to see if you get their names and phone numbers of those people. If it's a rear-end collision, that's probably not necessary because there's a presumption that rear-end collisions that the other person is going to be negligent. They're going to be at fault. And so, but if it's like who had the red light, who had the green light, who left the stop sign first, or one of these situations where there might be an argument, again, the police are a good way to contact them, even on a minor accident. The more severe the accident, the better to have rescue units out there and the police. Maybe drawing a diagram of the area while it's fresh in your mind. Quick Trip and other places have little diagrams. You can go up there and fill out these reports and try to get the information. Write it down on whatever you have at the time and then transfer it to those reports they have at Quick Trip. The law states if it's under $300 worth of damage, no police have to get involved. No reports have to be made to the state of Oklahoma. If you have more than $300 worth of damage, then you are required to report it to the state of Oklahoma. That's considered to be an official accident. That's the threshold for the official reporting status. That's important, but the problem is most people don't know what $300 worth of damage is at the time of the accident. So you may think it's $300 when in reality it may be $1,500 worth of damage. So as a rule, again, try to rely upon the police and have them come out and document all that for you. Insurance information is going to be very important because at some point you're going to want to get your car fixed. At some point you may be injured and you may be looking at that other person's insurance to give you some type of monetary relief for the damages you have. Despite common wisdom out there, you're not entitled to a settlement. You're not entitled to have your car settled. You're not entitled to have a settlement for your bodily injuries. And that could be the next subject of the next segment. But I wanted to kick it back to you, Doc, and see if that's the answers I've given so far.
Well, I noticed that a lot of times people will make a mistake. They don't know, probably as you stated earlier, it's not necessarily a mistake, it's not knowing what to do. But they do things that hurt them from a legal standpoint.
Oh, absolutely. As the case starts developing, then they start getting into things like what not to do in a situation like that is give the insurance company any kind of control. As I kind of alluded a minute ago, you really don't have a right for a personal injury settlement. It's all a matter of persuasion, and it's persuaded by evidence. Evidence is a legal term. Evidence is something that is able to show, be able to prove what you're saying or what you're damaged is in fact what it is. A car damage may be a little bit easier to be able to explain. You have damage to your car, you get an estimate for your car, you might have a rental car. Those sort of things are damages, and then you go to the insurance company and they say, wait a minute now, we see you have an estimate here for $1,500. Well, we have an estimator that thinks there's only $700 worth of damage. So you get into this situation to where you might be at odds dealing with somebody who's a professional at doing that. That's the reason why a lot of people hire lawyers, so you can have a professional be able to bring the fight to them. But as you mentioned, there are things that you don't want to do. You do not want to give a tape-recorded statement to the other person's insurance company. It's just not in your best interest. What that is doing is that is memorializing a particular fact into evidence, and that evidence is your testimony, it's your statement. So for example, if you talk to an insurance company 2 days after the accident and they say, well, were you hurt? Well, that person at that time on that day may have a little bit of stiffness in their neck, their shoulder, or may have some complaints, they might have a slight headache, but they're not thinking that they're really injured. 2-3 days later pass on, all of a sudden they've got the situation where their symptoms are getting worse and they feel compelled to go get to a doctor. Well, if they give a statement to the insurance company and they said they weren't hurt, now they have a fact that changes after they've already given testimony that they weren't hurt. Well, you can imagine that's going to cause problems. The insurance company is going to feel comfortable in defending the case and say, well, wait a minute, Mr. Jones, you told me you weren't hurt. I've got that statement. Now all of a sudden you're hurt? Well, we're just not persuaded, and we may not even be wanting to settle with you. Either way, it does diminish the value of the case. It hurts the case, and it gives the insurance company control. If the insurance company can control the case, they can control the outcome. Since you might be entitled to damages, your car damage, your bodily injuries, your lost wages, your future impairment, your loss of use, loss of consortium. Again, these are all damages that I'd be glad if you'd like to call me. I'll discuss those damages with you in detail. But for the purposes of this interview right now, damages must be proven. The stronger the evidence. And if the insurance company takes control of that, they will control the outcome. So do not give them a recorded statement. That's part of the areas where they start seeping in and want to take control of the case. Do not give them a medical authorization. There's no reason why they can have a medical authorization. Your attorney or yourself will be providing them documentation. What a lawyer does is we take a look at the records, we make sure everything's in the records that needs to be. We'll get things supplemented that are not in there, and we'll have some additional documentation embedded in with the medical records, again, to support it and make it stronger. The stronger the evidence, the stronger the outcome. When I say stronger the outcome, that generally means more damages that you'll be entitled to because you're able to prove those damages. Pain and suffering. Pain and suffering has to be proven. There's no set variable as to what pain and suffering is. In fact, most people think pain and suffering is ouch, I hurt, when in actuality, pain and suffering is what you can't do because ouch, I hurt. So if you used to go before the accident bowling every Friday night, then you get into an accident and your injuries are such that you can't even go practice or go bowling, or, well, that's something that goes towards the pain and suffering level of it. That's evidence of it. Well, what kind of evidence would you want to have in that? Well, what the lawyers do at that point is we prepare affidavits. We get with folks and people that knew you before and after the accident. We're able to get some evidence, but that has to be corroborated with a physician. And Dr. Bissland knows better than most out here that the daily activities that are disrupted are very important to tell you. Dr. Bissland, you come in, you treat. Dr. Bissland says, hey, how was it since the last time I saw you? Are you feeling better, worse? Any new symptoms? What's also important, as you as a patient in a personal injury case, to talk about the activities that you're unable to do. Well, Doc, you wouldn't believe this. Since the accident, I've not been able to go bowling. I can't even use my right arm. I can't even wash my hair in the shower. Whatever the case may be. Maybe you do volunteer work at the church or something of that nature, and now because of the accident, you're having problems with that. That's really setting up a basis, a foundation for a pain and suffering argument. Another thing I hear is people say, well, pain and suffering, don't I take my medical bills and multiply that by some magic figure, and that's what the insurance company will pay me? Excuse me. It doesn't actually work that way. That's an old myth. If it was that simple, we wouldn't have courthouses. We wouldn't even have insurance companies. We'd have an electronic database that you feed your bills into, and it spits out money because it calculates on some type of formula. Really, it doesn't work that way. Pain and suffering is unique to that person. It's not based on the medical bills. Here's an example. If I scratch my hand in an auto collision, and let's say I go to a doctor and he puts a Band-Aid on it, and let's say he charged me $5,000 for that office visit, and I give that bill to the insurance company. They're going to take a look at the bills, and they're going to challenge its reasonable necessity. And the pain and suffering associated with that, there's no way you can calculate that by that. It's a minor scratch, so it's going to be probably evidence of minor pain and suffering. What lawyers do is we look at that $5,000 Band-Aid, and all of a sudden we think, well, wait a minute now, let's take a look at this closer. It was $5,000, but he developed an infection. In fact, he has MRSA from it, has an open wound, has nerve damage from it. Now he has a disfigurement. So that might be a $5,000 Band-Aid. So we have to look at the evidence. The insurance company, if they take control of the case, if you're without a lawyer, you'll be disadvantaged because they're going to tell you what they have as far as evidence and how they're controlling the outcome on the case. Whereas the lawyer's arguing that, wait a minute now, that is a $5,000 Band-Aid, and we can back it up and we can prove it. And if need be, if we can't settle this matter out of court, we can go to the courthouse and persuade a jury to award us that money. So, and that's the key word, persuasion. You don't have a right for a settlement, but an insurance company can be persuaded to make a settlement with you based on the evidence, based on the strength of the evidence. And again, it's a matter of persuasion. It's a business decision for them. They're in the business of making a profit. They're a corporation. They're looking at the bottom line. You as an accident victim are entitled to damages. What you don't have is the right for a settlement, but you do have a right to go to a jury trial. It's your constitutional right. So that's what you have. And so at some point, the insurance company may be interested in buying that right away from you to take their insured to go to court. So it's kind of a commodity. I think I've always told people that my practice of law is more of an art than it is a science. And that is, instead of using clay to shape a vase and a masterpiece and then sell it to two potential buyers, one being the insurance company, the other one being the jury, well, I'm shaping a masterpiece out of evidence. It's not going to be clay, it's not going to be a vase, but it's going to be a masterpiece of evidentiary work. And I'm going to go to them, and they're going to take a look at it, and they might be interested in buying it. In most cases, about 75% of the time, I can get it resolved without even filing a lawsuit. But that's if I can get in early and develop a legal strategy. So back to some of the things you should do early on in the case is get a free legal consultation by a good personal injury lawyer. And I'd be honored to talk to you on those matters.
Okay, when we come back, we're going to talk about some of the new laws that have come into Oklahoma in the last year and a half, and any other information that happens to come up. So we'll be right back.
An accident can turn your life upside down. Immediately, you may face problems like who will treat your injuries? How will your car get fixed? What are you going to drive in the meantime? You need solutions now. At Benedict Law Office, the care you deserve can begin at your own home. No office visit is necessary, and you pay no fee if there's no recovery.
At Benedict Law Office, there are no problems, only solutions.
Call Benedict Law Office for your free consultation today.
Are you in pain? Then meet the doctor. Neck pain, headaches? Meet the doctor. Low back and leg pain? Meet the doctor. Arm, shoulder, and hand pain? Carpal tunnel syndrome? Meet the doctor. Injured in an auto accident? Meet Dr. James Bissland at Bissland Chiropractic, where you can get your first visit free this month. Call Bissland Chiropractic at 838-4252. Bissland Chiropractic.
Where were you when the lights went out? Who did you call and when you gave them a shout? Did they pick up the phone? Did you get a machine? Or some front office drone? You know what I mean. You wanna talk to somebody who knows what they're talking about. So call Marie now. Electricians with a mission will get you connected. We're Murray Electric.
Hi, this is Larry Murray with Murray Electric. We appreciate your business and we don't take you for granted. While nobody likes to have electrical problems, we want you to know that we will be here for you when you do need an electrician. And remember, you don't get phone shuffle when you call Murray Electric, because we have a real live electrician that answers the telephone. Remember, if you're in a hurry, call Murray, 918-835-9605. 918-835-9605.
We'll get you connected. We're Murray Electric.
Welcome back to Health and Information, February of 2013, and I'm here talking with Attorney Lloyd Benedict from the Benedict Law Office. And Lloyd, last month on our program, when I was Dr. Lana Pinnell was with us, we talked about the importance of people following a treatment plan when they're in an auto accident or when we're dealing with a personal injury. That becomes more important, doesn't it?
Becomes very important. In fact, the insurance industry has a term for people that don't follow the insurance or follow the treatment plan. They call it non-compliant. And that's just a little checkbox they have in there that devaluates the value of your case. In essence, it takes the sincerity out of your injury. The insurance company is not going to think that you're as injured as you really may be if you miss treatments. Missing treatments can happen in a couple of different ways. One, there's the delay of treatment, the people that just want to see if it's going to go away. So they might delay after the accident. The longer you wait to see a physician to get proper care, the less the insurance company is convinced the seriousness of your injury. Some people say, well, maybe it'll go away and I'll try to take over-counter medications and whatnot. People can be seriously injured and be walking around and just not, pain is not the only symptom of being injured. There's all types of things of range of motion problems and stiffness and soreness, and pain is just not necessarily a degree. So don't fall into that trap. Have yourself seen. If you've seen Dr. Bissland before, definitely get into Dr. Bissland as you can. I'm sure he'll make whatever arrangements he can to get into as quick as possible. The other type of treatment problem there is a gap in treatment. That's where when you see Dr. Bissland, as with a lot of chiropractors, they put you on a treatment plan, and that treatment plan is typically a regimen of coming in so many days a week for the first 2 weeks or 3 weeks. And then after that, it gradually decreases as you get better, as you heal, depending on who you are. So there's a structured treatment plan for you set up on a a daily basis or a calendar basis on that. The insurance companies look at that, and they look to see if you're being compliant. They say, okay, Dr. Bissland asked you to come here on Tuesdays, Wednesdays, and Fridays, and you missed the Wednesdays. You did that 2 weeks in a row. So, Mr. Jones, are you telling me that I should consider this medical bills if you're not even keeping up with what the doctor had told you to do, what he instructed you to do? You're not even trying to get better. If you're that hurt, then what's the reason for that? So what that does, that creates a weakness in the case, and it diminishes the value, and we have to go and explain that. And there may be some legitimate reasons. Maybe a person had a funeral. Maybe they couldn't get off work. Maybe they had to go out of town. Maybe they had the flu during that time. So there are some small exceptions, but very darn few. And so really, to stay consistent with the treatment plan that the doctor has prescribed is the safest way to go. Plus, from a health standpoint, it's the best way to go, obviously, for improving your health status. But evidence-wise, there's no need to give the insurance company more ammunition than they don't deserve.
Absolutely. Now, we know that over the period of a legislative session that the state Senate, state House of Representatives, they always are passing new bills.
Oh, constantly, yes.
So I know there's been some pretty significant changes in the Oklahoma law in the last year to a year and a half.
There has been.
Can you tell us a little bit of the ones that are the most important for people to know?
Absolutely, absolutely. Some of the ones what we refer to as tort reform measures, and really there's no such thing. The tort reform is really kind of the wrong term to use. Basically, what it is it's nullifying your rights, your constitutional rights to get damages as you may be entitled to, as you're afforded to have your day in court under our Constitution. So it's really kind of, the word probably should be corporate immunity or insurance immunity. The whole idea is they really don't want to pay money out. So they've come up with this this campaign called tort reform, and it has nothing to do with reforming torts. A tort is a civil wrong for which the court provides a remedy. So to give you an idea, if you've been injured in a car accident, that's a tort. That's a civil wrong, and you've been injured, and the courts can provide a remedy for that. So all this legislation that Dr. Bissland's talking about has been focused on taking your rights away as a victim and what you might be entitled to. For example, they have a new law that went into effect called no pay, no play. Maybe you've heard this, maybe you haven't. In essence, what it is if you are a driver of a vehicle and for some reason you did not have insurance, but you were hit by somebody else was at fault, they caused the accident, it's going to take your right away for pain and suffering. In fact, all you're going to be entitled to is your medical bills and lost wages, and not dollar for dollar. That's whatever the insurance companies consider to be reasonable. They may say, hey, that's a $5,000 Band-Aid. We're not going to pay that. So that's one of those tort reform measures. I don't get the rationale. Really, it's letting the responsible party off the hook. If they're really about accountability, well, aren't they kind of letting the person who caused the accident off the hook, and the insurance companies getting to save money on the deal, trying to say that, you know, just because you didn't have insurance, you're going to have to, that'll be your penalty for that? Not everybody has strong finances in this economy. Maybe you had to make a decision about paying rent versus paying car insurance. So we understand why people have to make tough decisions on financials, and it's not fair that you're penalized that way, but you are. There are 5 exceptions on that. I may be able to recall a few of them, but one, if you're a minor, if you're borrowing your parents' car and the parents did not have insurance, the no pay, no play will not apply to you. The other one is if the person who hit you was intoxicated and is convicted for a DUI. It's not that they get a ticket for it. So you have to stay on the prosecutor to make sure that that person who hit you gets a conviction, because they'll want to plea bargain that out sometimes under a first offense. And they need to know if that happens, then you'll be victimized, because you will not be getting your pain, suffering, mental anguish, permanency, future damages. It'll only be your reasonable medical bills and your lost wages. That's 3 of them. I can't recall the other 2, but if you call me, I bet you I can probably look them up. Some of the other laws that have gone into effect is they've capped damages. The most that you can recover for pain and suffering now in the state of Oklahoma is $350,000. That sounds like a lot of money, but that doesn't go far if you're 7 years old and you receive third-degree burns over 40% of your body, and you're going to be stuck with pain, suffering for the rest of your life. It's a travesty. It's, in my opinion, it's unconstitutional. But right now, until we get it reversed in the Supreme Court of Oklahoma, it is the law. There's some lien law changes, and I'll just kind of explain liens to you briefly. Liens, are something that are really a privilege. They were designed because a lot of people that were injured in accidents couldn't afford to go out and get care with the doctors. They just didn't have the money. They didn't have health insurance or whatever the case may be. So years ago, our state legislature said, you know what, let's allow people to get proper care, and we can develop something where the doctor can file a document at the courthouse and then send that off to the insurance company. So when and if there's a settlement or court award, the doctor will be paid from that settlement. So the doctor can, if he agrees to that, and I believe Dr. Bissland has lien-based care arrangements on that.
We absolutely do.
It is a way to take the stress off you so you can get proper care without having to pay as you go, as many other medical providers require to do. So it's a privilege, and it's not a scary thing. You may receive letters from these attorneys that say, hey, we noticed you had a lien filed against you, and come hire my law firm. They're trying to scare you. It's no big deal. It's a standard operating procedure as far as a document go to the courthouse. It won't hurt your credit. It doesn't go against your house. It only goes against the hypothetical event of whether you settle or get a court award. Now, should you not get a settlement or court award, you still owe for the bill, and that's something that you'd have to speak with Dr. Bissland about if those arrangements happen. I'm sure that they have their own procedures to deal with that. But as I mentioned before to you, the vast majority of the cases I represent, I'm able to get a fair settlement without even filing a lawsuit if I can get into the case early enough to develop a legal strategy to be able to turn it in that direction. Let's see, some of the other laws that have changed recently are things called the collateral source rule. If you have health insurance that pays for your medical bills while you're in a car accident, that can actually hurt your case. So you might not want to really use health insurance for those cases, because then the insurance company only has to reimburse you for whatever the health insurance had paid and not what your full bill might have been. Now, there's a few exceptions on that. It's kind of complicated, and again, I'll be glad to describe that to you later on, but those are things you have to be careful of. And something else you may want to also know too is you might have medical payment provisions. You might have that coverage under your own policy. That's a good thing. A lot of people say, well, why should I use my own insurance, my own automobile insurance, and more specifically, why should I use my own MedPay insurance? Well, because it's a benefit you paid for. You've paid that premium. It only pays for the circumstances when you're injured in a motor vehicle collision, and so that you can never use it any other time. And you can use it whether the accident was your fault or whether you're a victim by somebody else's negligence. But the law states that they cannot raise your premiums, they cannot cancel your policy, they can't do anything bad to you if you use your MedPay. So that's another thing, that's another misnomer people have. They're afraid to use their own insurance, when really that's a benefit that you've really got to sit back and really take full advantage of, because that's your hard-earned dollars that you paid that premium for. And if you never use that benefit, well, the insurance company's just going to profit just that much more at your expense. So those sort of things are areas that people really need to know. Again, I'm always glad to answer anybody's questions. Doc, if you ever have a patient that would like us to come out and meet them right here in the clinic, I'll be glad to do that. They're always welcome to call me at my office or send me emails. I have many ways to be contacted and answer any questions these have.
And on the screen, you'll see Lloyd's name, address, telephone number, and webpage.
Okay.
So that you are going to be able to contact him if you have a question. And I appreciate you being here. Thank you for your time. And
It's my honor, Doc. Once again, it's my pleasure as well.
thank you. And for those of you who have any questions about auto accidents from a medical standpoint, you're welcome to call me. Our office information is also now on the screen, as well as Lloyd's. If you have any legal questions, please feel free to call either one of us for our own specialty, and we work together very well to be able to help you resolve the issues that you have after an accident or a trauma. And thank you for joining us this month on Health and Information. We look forward to seeing you next month. Until then, have a healthy, happy, and safe month.